Good morning once again. So now we'll start again. Yesterday we discussed up to question number 50. Now question number 51. So this question is also from GFR. So copies of all sanctions or orders other than following types should be endorsed to the audit officer. So earlier we had discussed which type of documents should be endorsed to audit officer. Now it is being asked which question should not, or which type of document should not be endorsed to audit officer. So first is sanctions relating to grant to advances to central government employees. Next option, sanctions relating to appointment or promotion or transfer of gazetted non-gazetted officer. Sanction and contingent expenditure incurred under the powers of head of offices. So these all are, you can say, non-financial matters, or even if it is financial matter in option number 1, but this is related to advance, so these are not required to endorse to audit officer. So our answer would be all of the above. Next question, no government servant shall, except with previous sanction of government, participate in or associate himself in any manner in the making of, first, a sponsored media, radio or television program. Second option, a media program commissioned by government media but produced by a private agency. Third statement is a privately produced media program including video magazine. So these three should not be or shall not be done by the government employee. So our answer would be all of the above, option number D. Next question 53, for which among the following the previous sanction of the government is not required by a government servant? Option number A is undertake honorary work of a social or charitable nature. Second is undertake occasional work of a literary, artistic or scientific character. Third is participate in sports activities as an amateur. So as you know, these are the options which are, you can say, either in social nature or literary or artistic, or even in a sports. If you are participating as an amateur, then that doesn't require previous sanction of government. So our option or correct answer would be all of the above, option number D. Next question, consider the following statement and comment. First statement, every government servant shall report to the government if any member of his family is engaged in a trade or business or owns or manages an insurance agency or commission agency. Second statement, unless otherwise provided by general or special orders of the government, no government servant may accept any fee for any work done by him for any private or public body or any private person without the sanction of the prescribed authority. So our answer should be what? Our answer should be C, because both the statements are correct. So public fee, or you can say fee, should not be accepted without sanction from the government. Or first option, as it has been mentioned, that if your family member is engaged in trade or business or owns or manages an insurance agency or commission agency, that must be reported to government. So both the options are correct. Both the statements, sorry. So both statement 1 and statement 2 are correct. Next question. This is very important. Generally people practice, mainly government. We are talking about people means here government servant, not common people. So question is, subletting and vacation of government accommodation is provided in which rule of CCS Conduct Rule 1964? So our answer should be, we'll see the rule 15A, it is not correct. Rule 13B, this is also not correct. Rule 17, this is also not correct. And rule 15. So actually 15 is not correct answer, 15A is correct answer. So our answer would be rule 15A. So option number A would be the right answer. Next, question number 56. Government servant who sublets the government accommodation are liable for disciplinary proceeding under. So we have read in CCS Conduct Rules 1964 Rule 15A that subletting is not allowed. Now question is, if you do it, so under which rule you will be charged as per CCA rules 1965. So options are rule 14 of the CCA rule, rule 16 of CCA rules 1965, rule 18 of CCA rules 1965, and rule 19 of CCA rules. So as you know, there are two proceedings, minor penalty and major penalty. So you know, these are processed or proceedings are initiated as per two rules, you can mainly say, and these are rule 14 and 16. So our answer would be either A or B. So option number C and D are wrong, directly wrong. So now we will check. For rule 14 it is major penalty proceeding and rule 16 is minor penalty proceeding. So since this is related to violation of government guidelines, plus there is, you can say, misuse of government property, so this will form, you can say, major penalty proceeding. So correct answer would be option number A, rule 14 of CCS. As you know, under rule 14 major penalty is initiated, and under 16 minor penalty is initiated. So our correct answer would be rule 14. Next is, no government servant shall speculate in any stock, share or other investment as per rule of CCS. Which rule? So again you have to remember that here what is the meaning of speculation. Speculation means you are a kind of person who is regularly buying and selling the share. You can make the investment for longer period, however you should not buy or purchase shares or stocks regularly. And why so? Because you may be giving more and more time to this, and this is a kind of business for profit purpose. And as you know, government servant cannot do business while being in government service. So that's why you are not, you means government servant. Government servant is not allowed. So our correct answer is rule number 16 of CCS Conduct Rules 1964. Next is rule based question, again rule based question. And actually CCS Conduct Rules, you have to remember rules. There are some provisions and you have to remember, and you have to make a method or devise a method how to remember the rules for CCS Conduct Rules. So question is, insolvency and habitual indebtedness is mentioned in which rule of CCS Conduct Rules 1964? So again rule option, your option is option A rule 11, option B rule 14, option C rule 17, and option D rule 20. So this is related to insolvency and habitual indebtedness. So your correct answer should be rule 17. Remember, continuously we will see there are some rules related to financial matters, like rule 15 we had read, towards subletting. So that was rule 15A. And again we read about rule 16, that was related to what? A speculation, like again money matter. So this was 16. And again if you are indebted, then this is also related to financial matter. So here rule number 17. So you know, insolvency means you don't have money, you are indulged in a kind of business and you lose everything, so you will become insolvent. And habitual indebtedness also. So time and again your habit, you are not leading your life as per your income, and time and again you are taking loans from others, especially private parties. So that habitual indebtedness, you can say, brings down the image of a government servant. So you are not allowed to do so. That's why it is prohibited. So again this is financial matter, because see, not only financial matter, as you know, a government servant is a representative of government. So you are supposed to do or act as a being of government, and you have to lead a very decent life, or you can say you must be an example for others, especially for public, that how you can say how a representative of government is leading his or her life. So we should remember that. We cannot, that's why you have been given a special protection also, that if you are a government servant, then nobody can simply take any, you can say, action which is not as per rule or law. So that kind of protective measures are also there for government servant. So question number 59. Your next question is 59. As per which rule of CCS Conduct Rules 1964, no government servant shall, except with the previous sanction of the government, have recourse to any court or to the press for the vindication of any official act which has been subject matter of adverse criticism or an attack of a defamatory character. See, being a government servant, directly you cannot go to press just to express your views uh, that related to your official act, and where there might be, you can say, criticism for government, or that would be um, defamatory character, so that is not allowed, and we are not here, we means a government servant. So for this question, answer would be rule 19. Next is under rule 19 of CCS Conduct Rules 1964, previous sanction of the government is required have recourse to any court to the press for vindication of any official act. If no such sanction is received by the government servant within a period of what months from the date of receipt of his request by the government, he shall be free to assume that the permission as out for has been granted to him. So if the permission has been given or has not been given during this period, then that's fine. So your options are 1 month, 2 months, 3 months, or 6 months. So correct answer is 3 months, option number C. Next question. It shall be the duty of a government servant who may be convicted in a criminal court to inform whom of the fact of his conviction and the circumstances connected therewith as soon as it is possible for him to do so. So question number 61. So answer, you can check official superiors, head of office, disciplinary authority, appointing authority. Remember, you can eliminate some options like appointing authority, disciplinary authority. These authorities are, or you can say at least disciplinary authority, that comes in picture only during any, if there is any disciplinary proceeding. So option number C would not be there. Appointing authority may also be eliminated because most of the cases appointing authority is the highest authority of any department or organization, where appointing authority is not looking after day-to-day activities. So these two should be eliminated. Now you have two options left. First one is official superiors and second one is head of office. So since the official superiors are the immediate connected with government employee, so it should be the correct answer. So the answer would be option number A, official superior. Next question, we will discuss next question. Question number 62. Whether prior permission is required by government servants seeking redress in courts of law of their grievances arising out of their employment or conditions of service. Since you can see this is related to service matter of government servant and he or she is aggrieved from the employer itself, so it is not required to seek the permission, because if you are aggrieved from the employer itself, so how you will take the approval. So that's why this is not required. So your right answer should be no, it is not required. Prior permission is not required. So answer would be option number P. Next question. As per which rule of CCS Conduct Rule 1964, no government servant shall bring or attempt to bring any political or other outside influence to bear upon any superior authority to further his interest in respect of matters pertaining to his service under government. So remember one thing, that even if you are having any connection with any political party or political figure or any other person who is having, you can say, some influence, then you must not bring those influences to your office, because it would be the violation of the CCS conduct rules. So that should not be there. So we have to see which rule we have to follow for this. So as you remember, you can eliminate here option number 17, because 17 was related to indebtedness or something, a speculation. What was that? We can go back to question or correct answer. 17 was related to habitual indebtedness. So here this 17 option would not be there. So here correct answer is rule 20. So while reading CCS conduct rules, time and again we have to just repeat it, or we have to review it, so that it is updated, or you can say we can easily solve the questions related to CCS conduct rules 1964. Next is restriction regarding marriage is provided in which rule of CCS conduct rules 1964. So this is a very important question. So marriage is related to under which rule we will see rule number 18, rule number 21, 25, 32. So our correct answer is 21. You remember rule 21. 21 is also related to, if you remember, article 21. So you know, in article 21 what are the important points in article 21. One is the that is, you can say, liberty, life, liberty, you can say, and 21 is there related to right to education. So here this relates to marriage here. So your answer would be 21. Next question. Which among the following statement is or are correct with regard to CCS conduct rules 1964? Statement 1. No government servant shall enter into or contract a marriage with a person having a spouse living. Option number 2. No government servant having a spouse living shall enter into a contract or marriage with any person. So both the options are correct, because no government servant shall enter into a contract or marriage with a person having a spouse living, and other says no government servant having a spouse living. If you are having a spouse living, then you cannot marry or you cannot contract. So your answer would be option number C. Next question, prohibition of consumption of intoxicating drinks and drugs is provided under rule of CCS Conduct Rule 1964. So here correct answer is, you can remember that you can just eliminate here rule 17, that is habitual indebtedness and insolvency. Rule 14 and 11, they are also not related to this consumption of intoxicating drinks. So these three will be eliminated. Your right answer would be rule 22, option number C. Next question, prohibition regarding employment of children below 14 years of age is provided under which rule of CCS Conduct Rule? This is also very, very important. Means you cannot practice child labor. It is a kind of prohibition on child labor. So if you engage any child who is below 14 years of age, it means you are engaging minor in respect of child labor. So you can be booked against, or you can be charged against this rule. So our answer is rule 22A. Two options are same actually, rule 15 and rule, and here grammatical mistake is also there, RUL rule. Anyway, our answer, correct answer is rule 22A. Next, as per rule 22A of the CCS Conduct Rule, no government servant shall employ to work any child below the age of. Again same question has been actually repeated, previous question. So if you remember, it is already mentioned here 14 years of age. So 14 years of age means here your option would be B. This was quite easy, just repetitive question. Next, rule 11 of Central Civil Services Conduct Rules 1964 governs 11. So remember 69. This is very important. First option is criticism of government, evidence before committee or any other authority. Third option, unauthorized communication of information, and D is subscriptions. So here unauthorized communication of information, until a government servant is authorized, no information related to government or his or her office should be communicated to any person. Next question is, subscription is covered under which rule of CCS Rules 1964? So question number 17. Number rule 12, options are rule 12, rule 17, rule 21, rule 6. So as we have discussed, you can eliminate two options. Option number 17, that is related to insolvency and indebtedness, habitual indebtedness, and 21 is also related to marriage, provision of marriage, you can say marriage provision is there. So these two can be eliminated immediately. So our correct answer would be rule 12. Now here comes rule 13 of CCS Rules 64. 4. So 13 is related to what? Option A are subscription, gifts, private trade, or employment. Next option, movable, immovable, and valuable property. So as we discussed that after you can say 13, 14, 15, 16, these all are related to financial matters. So here you can see our options. Gift is the gifts. This covers under, this is covered under rule 13. Now question number 72. The expression gift under rule 13 of CCS conduct rules 1964 includes, first is free transport, second is boarding, third is lodging, fourth is casual meal. So you can see what would be covered under the, you can say, word gift. What would form gift? So your free transport, that would form as gift. Boarding will also form as gift. Lodging will also form as gift. So casual meal will not form as gift. The word itself is casual. So your answer would be 1, 2 and 3 only. So option number C is correct answer. Next question, which among the following shall not be deemed to be a gift as defined under CCS conduct rules? So again, casual meal will not be considered as gift. Next is lift. Sometimes you are traveling but you don't have any transportation facility and someone is giving the lift, so that lift would not be treated as gift. And other social hospitality, so if there are some customs where one can know government servant also, and that kind of social hospitality would not form as gift. So all of the above would be a correct answer, option number D. Next is, if the value of gift received by a group A officers in conformity with prevailing religious or social practices exceeds, he should report to the same to the government. So this is related to actually group A officer. So correct answer would be rupees 25,000. And the same thing, this is related to group B officer. So for group B the limit is 15,000. So for group A it is 25, for group B it is 15,000. So next question, and for group C again that is 7,500. So just if you remember, for group A 25, then for group B it is 15, group C half of that, means 7,500. Option number C is the correct answer. So next question, a government servant shall not accept any gift without the sanction of government servant if the value thereof exceeds rupees 5,000 in each case of government servant holding any group A or group B post. Rupees 2,000 in case of government servant holding any group C post. So here I think previous questions were related to group A, B and C, but that was in different perspective, and it is in different perspective. Rupees 5,000 in case of government servants holding any group A or B post, and for group C rupees 2,000 in case of government servant. So here both the statements are correct, so there should not be any confusion. You can see the specific words were there, like if the value of gifts received by a group of C officer in conformity with the prevailing religious and social practice. So this will form a different limit, but in other case this limit would be there. Next question, a government servant being a member of the Indian delegation or otherwise may receive and retain gifts from foreign dignitaries in accordance with the provision of. So under which provision a gift can be retained by government servant from foreign dignitaries? So for that we will see options. India's Foreign Regulation Act 2014, Foreign Contribution, Acceptance or Retention of Gifts or Presentation Rules 2012, or Indian Foreign Trade Agreement 2019, CCS conducted 1964. Actually, once you are receiving the contribution from foreign dignitaries, so here relevant provisions are there under Foreign Contribution, Acceptance or Retention of Gifts or Presentation Rules 2012. So this is the correct answer. Next question number, financial limit of receiving gifts as mentioned in Rule 13 of CCS Conduct Rules 64 has been last amended in the year. In which year it was amended? So it was amended in 2019. So your correct option would be option number B. So dowry related provision, this is very famous, you can say. You must remember, and everybody should remember this provision, because this is often asked in different examination, and this practice is actually prevalent in each society in different forms. So we can see the option Rule 13, Rule 17, Rule 18, Rule 13A. So 13A was something else, 17 was something else, means related to habitual indebtedness and insolvency. 18 was also not related to dowry, and now you have left only Rule 13A. So our correct answer would be 13A. Next is, public demonstration in honor of government servant is covered under which rule of CCS? Rule 1964. So we'll see rule number 14 options, Rule 16, Rule 9 and Rule 21. So again you can eliminate at least two rules which we have already discussed. Rule 21 related to marriage proposal, marriage related provisions. 16 related to other financial matter that was related to a speculation in share or something like that. So that would not be the answer. So now you have left with rule 14 and rule 9. So your correct answer is rule 14. Option number A. Next question, section 15 of CCS. Next question, where is next question? 82. Section 15 of CCS conduct rules 64 prohibits what? This is section 15 of CCS. So this prohibits what? Dowry will not be there because it was under rule 13A. Investing in a stock, it was also not there. This was related to different rule or rule number 16. So you are left with private trade or employment. So your answer would be B, private trade or employment. Next, as per rule 15 of CCS rules 1964, no government servant shall except with the previous sanction of government engage directly or indirectly in any trade or business, negotiate for or undertake any other employment, hold an elective office or canvass for a candidate or candidates for an elective office in any body, whether incorporated or not. And option number D, all the above. So these all three above three would be covered under rule 15. So our answer would be option number D. Next question, which of following is not a correct assessment with respect to the preamble of Indian Constitution? So as you know, preamble is a very, very important document for anybody. As you know, so many things or so many important things are there in preamble, but main important thing is that it is not enforceable in court of law. So like socialist, equitable, fraternity, these all so many important things are there, but these are not enforceable. So what is enforceable? So fundamental rights which are mentioned in part 3 of the Constitution are enforceable in court of law. So this is incorrect. Question was, which of the following is not a correct statement? So this is not correct because it is saying that preamble is enforceable in court of law. Others are correct. You can see it depicts the nature of Indian states. It defines the objective of Constitution. It mentions the date of adoption. That was, what was the date of adoption of the Constitution? If you remember, recently we have celebrated that day as Constitution Day. That is 26th November. It was adopted on which date? 26th November 1949. And as you know, any preamble defines the objective of the Constitution. Any Constitution of any country. You can say Constitution of any country. And as you have seen, our country would be democratic socialist country, so that you can say the nature of Indian state has also been depicted in preamble. Next is, which among the following information is not exempted from disclosure as defined under section 8 of RTI Act 2005? Information disclosure of which would prejudicially affect the sovereignty and integrity of India. Information related to UPSC. Option C, information which has been expressly forbidden to be published by any court of law or tribunal. Option D, information available to a person in his fiduciary relationship unless the competent authority is satisfied that the larger public interest warrants the disclosure of such information. So if you see the options, you will feel that option number B, information related to UPSC. So this is a kind of just information, so this cannot be exempted. So that's why our correct answer would be option number B. Others are, you can say, specific and appropriatory in nature, so that would be there under section 8 of RTI, but option B is not there. Next question. Question number 86. Information which would impede the process of investigation or apprehension or prosecution of offenders shall be denied under which section of RTI Act 2005. So this is very, very important. So if any information can impede the process of investigation, then that shall be denied. So for that, section is section 8H. Simply you have to remember this. Next is severability clause is provided in which section of RTI Act 2005. So what is the correct answer? Our correct answer is section 10. Next question, third party information. This is famous, you can say, questions for RTI. Third party information, this is covered under section 11. Next question, where a notice is served to a third party under RTI Act 2005 in respect of any information on record or part thereof, the third party shall, within how many days from the date of receipt of such notice, be given the opportunity to make representation against the proposed disclosure. So question number 89. So that have how many days of time? So that period of time or limit of that period is 10 days. Within 10 days, any representation must be submitted. Otherwise, information would be shared. Next question. Under which section of RTI Act 2005 CIC, Central Information Commission, is constituted? So under section 12, CIC is constituted. What is the maximum number of CIC What is the maximum number of Central Information Commissioner? So we have to check the maximum number. What is the maximum number? So maximum number would be 10. So our answer would be A. The Chief Information Commissioner and Information Commissioner shall be appointed by whom? You can guess. As you know, as per RTI Act, it is means these officials are appointed by President of India. So your answer would be option number D. Next question is, who among the following is not a member of the committee to select Chief Information Commissioner and Information Commissioner? So Prime Minister, who shall be the chairperson, leader of opposition in the Lok Sabha, leader of opposition in the Rajya Sabha, Union Cabinet Minister to be nominated by the Prime Minister. So leader of opposition is there, but that leader of opposition should be from Lok Sabha only, not from Rajya Sabha. So our answer would be option number C, leader of opposition is Rajya Sabha. Next is headquarters of the CIC is situated at, where the headquarters is. So our correct answer would be New Delhi, option number C. Next question. Which among the following with regard to holding the office of CIC is correct? We have to say correct. Statement 1. CIC shall hold office for such term as may be prescribed by central government. Second option, CIC shall not be eligible for reappointment. Option next statement, no Chief Information Commissioner shall hold office as such after he has attained the age of 65. So we have to check correct option or correct statement. So first is the term is decided by central government, so that is correct. Next is reappointment, CIC is also not reappointed, that is also correct. Next is the limit is 65, so that is also correct. So all the above statements are correct. Next question, terms of office and conditions of service of CIC and IC as contained in section 13 of RTI Act 2005 were last amended in the year. Again, as you know, it was amended in the year 2019, where the Information Commissioner is appointed as the Chief Information Commissioner. His term of office shall not be more than how many years in aggregate as the Information Commissioner and the Chief Information Commissioner. See, it is asking that if any Information Commissioner is appointed as Chief earlier someone was working as Information Commissioner and he or she has been appointed as Chief Information Commissioner. So here period would be considered for both the posts. So combined period of both the posts should not be more than that period. So that period is 5 years. So your answer would be option number C. Next question is,